Yes, good afternoon to everybody. That today the class is as usual because the timings are different. Because of the morning I was busy in different activities. That's why I made it to the evening class. That is 3:45 for the Transfer of Property Act, and for other people I give the time the
Good,
5 to 5:45.
good
Yes, I could
afternoon,
hear it.
sir.
Very good. Good afternoon. Good afternoon to everybody. That I heard your sound. Thank you very much. Rather than before I could say something to that. Whether you can read that what I put it on the screen. Anyone, I used to say. But this time that you made the answer immediately so that I could know that the people are present and they could be hearing me. So this is the good evening good afternoon salutations that I put it on the screen. And now I will so go through the syllabus is concerned. As per the syllabus is concerned, that the next topic is because we cover the kinds of property, we cover the transfer of property, then we say the what is the transferable or not is non-transferable. There is a section 6 concern, and we dealt it with the exceptions total 10. If I not be mistaken over there from A to I, where the double D also is present over there. And who can transfer is the question that I would like to see it in this class. Means generally a person who is a competent to contract can transfer. That is generally the say because transfer is nothing but is a form of a contracting, and where the transfer could be made in many other ways. Yes, how the transfer can be made in the many other ways? Anyone can give the answer to the question? Yes, unmute and give the answer. Yes, unmute and give the answer to my question. Did you understand the question first?
ఎన్ని రకాలుగా ట్రాన్స్ఫర్ చేయొచ్చు?
Yes, that is the point that I asked over there. But ఎన్ని రకాలుగా ట్రాన్స్ఫర్ చేయొచ్చు?
వారసత్వంగా ట్రాన్స్ఫర్ చేయొచ్చు, లీగల్‌గా ట్రాన్స్ఫర్ చేయొచ్చు.
వారసత్వంగా ట్రాన్స్ఫర్ చేస్తాను ఏమంటారండి? Testate succession, yeah, intestate succession in the form of a will. So we can transfer by the sale. We can transfer by the
సేల్, లీజ్, గిఫ్ట్. ఓకే.
So these are the things that you have to say it. Huh? And there also we read we can transfer by the easement also, because easement also is one of the different form of it. Actually, it's not come on the different form of it, but automatically it will be transferred in certain cases because ఆవు అమ్మినప్పుడు దూడ కూడా అమ్మాలా. So that was the thing that we will see it in the license or other things are concerned. So in this class, that who can transfer means if you see the section 7, it gives that who can transfer, and a person who is a competent enough can transfer. Who is the competent enough? Yes, a person who is a major, number one, sound man, number two, and he should be the owner of the property, number three. Number four, to whom that he is transferring, generally he should be a living person, okay, or a juristic person also, yes, it will be there. So these are the things where you can, that person can only transfer. Can a minor will transfer the property?
నో సార్.
Answer is no.
గార్డియన్.
But a minor can be a transferee. He can receive the property, even though he is the minor. Because on behalf of the minor, the guardian will come into the point and he will accept of it, any property is concerned. So when you want to say the essential of the transfer under the Transfer of Property Act, means one of them is competency also comes over there. When you say the essential of the transfer under the Transfer of Property Act, where you will come across that different other things also, and there are total 8 essentials of a valid transfer of property. Number one, the transfer of property must take place between 2 or more living persons. Whenever you want to transfer, at least there should be 2 or more living persons should be there. Of course, here, sir, even the property can be transferred to the juristic person. Yeah, if we consider the artificial person, then can we say it is a living person? But we will treat them in that way. Let us see that what will happen in that when we go further. Yes, the second is the property transfer must be transferable. Yes, we read it in section 6. What cannot be transferred, we read it. Like special succession is there, re-entry is there, and some of the easements are there, and the other claims are there. So around about and future maintenance is there. So around about 10 are there in general that those cannot be transferred. We read it under Section 6 of the Transfer of Property Act. Yes, other than those exceptions, other property can be transferred. They say any other property. So that was the thing which is clearly said over there. Number 3, the transfer must not be opposed to the nature of the interest affected thereby or of any unlawful object or consideration of a person legally disqualified to be a transferee. So who is the disqualified to be a transferee? We have seen in section. Yes, we have seen
సెక్షన్ 6 సబ్సెక్షన్ ఎఫ్ ఏదో ఉంది సార్.
section 6. Neither property cannot be transferred. దాంట్లో కెనాట్ బి ట్రాన్స్ఫర్డ్ లో ఉన్నది. కాకపోతే ట్రాన్స్ఫర్ ఇన్కాపబుల్ ఆఫ్ ది ట్రాన్స్ఫరీ అని చెప్పాము ఒక సెక్షన్ లో. ట్రాన్స్ఫర్ ఆఫ్ ప్రాపర్టీ అంటే ద పర్సన్ ఇస్
ఇన్కాపబుల్ అంటే లీగల్
పర్సన్, జడ్జెస్ అండ్ ద what I say, court staff. These persons are not supposed to purchase or the auctions or any actionable claim because they are disqualified as a transferee. So that we read it over there. Yes, who can transfer, who cannot be transferred, but opposed to public policy is there and so and so. So that we study under section, under part 4. That is the 4th essential. Then the 5th essential is the transfer must be made in the mode prescribed by the Act. Yes, if the Act says it should be registered, means it should be registered. The Act says it is a oral. Of course, never the Act says it will oral, because if oral is there, there are heavy complications are there. So better it would be put it in writing and either on the stamp paper, preferably, and signed by the parties, respective parties, both the parties, plus both the parties side their witnesses also. So the legal implications will not be there, hurdles will not be there. Thus, all the necessary attestation and registration must be complied with. Though that the 5th point, that is one of the essential for the transfer of the property. And the 6th is the transfer must not offend the rule against the perpetuity. Yeah, rule against the perpetuity is there. So that is also will not offend the rule of perpetuity. In the sense, only 2 lifetimes we can give it. For 3rd lifetime, it is impossible to give it. So we will study in the further classes what is the rule of perpetuity. The 7th point is, if on the transfer of interest is created in favor of an unborn child. Suppose if an unborn child would be there, then how a property will be transferred? So that we will see that our unborn child, subject to the prior interest created with the same transfer, it must exhaust the whole of the remaining interest of the transferor. So there the conditions they say put it over there, how a unborn can also get the property under the Transfer of Property Act. Then the last one is, if the transfer is conditional, the condition must not be illegal or impossible or immoral opposed to public policy. So you don't put the condition that suppose if you put the condition that if the sun rises in the west, I will give 1 lakh rupees to you. Is it a valid contract? Is it a valid transfer? Why?
నో సార్,
Why?
అది పాసిబుల్ కాదు.
అంటే సన్ ఎక్కడ రైజెస్ అవుతుంది? ఈస్ట్ రైజ్ అవుతుంది. Because with thing which is impossible over there, for that we cannot transfer the property. అరే నేను తాజ్ మహల్ నమ్మేస్తా. Can you do it? It is not your property. It is the property of the endowment or central government archaeological department, because that will take care of it and they are the owner, said to be the owner of the property. So now the question comes over there. The Transfer of Property Act 1882 governs the provisions related to the transfer of property by the act of the parties as opposed to the transferring with the operation of law. Because transfer of property is based on the transfer by the sections which is clearly mentioned over there, but not by operation of law. Like auction. Auction will not come under the transfer of property because that is the operation of law. And it relates to the transfer of property inter vivos, means 2 living persons will be there. That's called inter vivos. That between the living persons. The term transfer includes the transfer through sale. Here, one of the mode, mortgage. Second mode, third, lease. Fourth, actionable claims. Fifth, gift or exchange, etc. In this way, that the property will be transferred. This act specifically deals with the transfer of the immovable property, and generally movable property, if you give the physical transfer itself, it's enough. It is said to be the transfer of the property. Transfer of property is defined to mean any act by which the living person convey property in present or in future or to one or more living persons or to himself and one or more living persons. The term persons includes companies. So even the person also come in, the company is also juristic person, that's why we'll say it. Even the body corporate and our association, either incorporated or corporated, doesn't matter in India. In the Preeti Singh versus Ganesh is one of the case law. It was held that the term property includes property situated outside the India or in territories where the act does not apply. So if the transfer of property will be applied only in India, not in Bangladesh. Is it right?
Yes, sir.
Why?
It Indian law, Indian property, no?
Because whenever the law would be there, that in the sovereign country it will be applied over there. Because each country is a sovereign country. So nobody will obey somebody else unless there is a treaty or something like that. Then it can be considered otherwise. That country law would be applied there where the country is situated. Suppose IPC will be not applicable in the England or any other country, because the IPC sections are a little bit different from one country to another country, even though the IPC is the replica of the England. But certain variations are there because the new sections are emerged over there. That's why that we could find the variations. So if the law of the land or law of the land of the law of the land can be used over there. So that would be the point. If the transfer is effected at a place where the act is in force, the right of and the liabilities of the parties will be determined by the act that the location of the property will be immaterial. Suppose sometimes location may be immaterial, they will say. Of course, that becomes the movable or immovable property. But immovable property is concerned, naturally that country law would be applied where the property is situated. That is the lex situs. And regarding the movable property is concerned, at that instance, either transfer or the operation of law or any other thing will be happen because of the domicile of a particular person, based on that thing, the country law would be applied for the disposal of the movable property. Yes, now we will see the one essential of another essential to know that what are the differences between them. So the first essential is that the transfer of property must take place where between the two or more living persons. Yeah, the living person means one living person, another a company or a group or an individual. So the transfer of property must be take place inter vivos, means two living person, means to the property must be transferred between two or more persons who are living. The transfer and transferee, a person who transfers is called transferor, and a person who receives the property is called transferee. So transferee spelling is TRANSFEREE. That is the spelling must be living entities on the date of the transfer. Therefore, there shall be an act of conveyance by some living person to constitute transfer. So when you want to constitute a transfer, there should be one living person should be there. Can the two living persons, then the two non-living person can transfer the property? The answer is as per the definition is concerned, at least one should be a living person. So that is the point over clearly said. And the second point is concerned, the property transferred must be transferable. So what is transferable visa? All property can be transferred except the condition there. Special succession is, we already dealt it. The chance of the relation obtaining the legacy on the death of the kinsmanship, that is called apparent legacy, and any other possibility like the nature that is nature similar to that mentioned above that can't be transferred, of the similar nature if it comes that cannot be transferred. Right of re-entry, yes, we discussed, and an easement right we discussed, and interest in the property restricted in its enjoyment. I told you already that the Padmanabha temple, the property belongs to their only clan only, but no other person could take, even including the endowment. So the interest in the property restricted in its enjoyment, okay, to the owner, because if any Purohit would be there, if any article would be there, that will be belongs to him, but he cannot transfer it. Of course, once he got taken it with the sole authority, again he can make it whatever he want. but when he has taken it to the position. For example, religious offices or services tenures and inalienable laws, inalienable things are there, can't be transferred. Such a thing would be there. Array, meeku the person who's staying in the house can be allowed for the swimming in the swimming pool. It doesn't mean the visitor also allowed to use the swimming pool. Even in the multi-story buildings, outsiders' cars should be parked outside. Outsiders' cars will not be allowed inside. There is a clear cut, there is a caution board would be there in the multi-story building. So if any other person who is outsider, at that instance, he has to keep his car or vehicle outside only, but not in the cellar, because each one got their own specific place for keeping the parking, because the parking place also having the registration plus the amount should be paid over there. Otherwise, there is no parking place. But they can say that, okay, there is a two-wheeler parking place, but not the four-wheeler parking place. That way they will impose it. So now a right to future maintenance also cannot be transferred over there, and a mere right to sewer can be not be transferred. A public office salary stipends of the military and such thing also cannot be transferred. And transfer can be made is opposed to the nature of interest affected thereby. That the transfer of service of inamdars, pata lands, and that cannot be transferred over there. And that is called residuals like air or water are from a river, because abstract things are there. You cannot transfer the air, you can transfer the air, light and water and river, because that is everybody's property. Yes. So transfer can be made by an unlawful object also, it is considered. Lastly, transfer can be made a person who is legally disqualified to be transferring. Like I showed you, Section 136 of the Transfer of Property Act, where the judges and the court officials will not be allowed for owning the property which is sold on the auction or by the actionable claims. So those are the things would be there. And when we can make it out, the other point is concerned res communes, which means things of which no one in particular is the owner. And that is, the men may use it. Such things can't be transferred by people. There are things which belongs to nobody. For example, air, nobody's owner. Water, nobody's owner. Sunlight, nobody's owner. These things are incapable of being apportioned. So res extra commercium, which means things throughout of the commerce, such as the property dedicated to a DT అంటే ఏందండి, ఎవరైనా చెప్పాలా? Yes, unmute and give the answer to my question. DT, DEITY, DT cannot be transferred. ఇది DT అంటే ఏంటిది? తెలుస్తుందని చెప్పండి, లేకుంటే తెలియదని చెప్పండి, లేకుంటే పాస్ అని చెప్పండి. ఐ విల్ గివ్ ద ఆన్సర్. ఎస్, అన్మ్యూట్ అండ్
No, sir.
ఎస్, పాస్ ఆన్. ఇస్ ఇట్?
Yes, sir. Yes.
ఇప్పుడు రాముడు, కృష్ణుడు, సీత ఇవి అన్ని ఏమంటారండి ఇంగ్లీష్ లో?
Devotional, sir.
అఫ్ కోర్స్ దే ఆర్ ద లార్డ్ అంటారు, గాడ్ అంటారు, లార్డ్ కృష్ణ అంటారు, లార్డ్ రామ అంటారు. అంటారాలేండి.
Yes, sir.
ఆడోళ్ళని ఏమంటారండి? సరస్వతి, పార్వతి.
దేవతలు.
ఇంగ్లీష్ లో చెప్పండి.
లక్ష్మీ మాత, సరస్వతి మాత. ఇంగ్లీష్ లో తెలీదు.
గాడెసెస్ లక్ష్మి, గాడెసెస్ సరస్వతి, గాడెసెస్ సీత. దిస్ వే దట్ విల్ మేక్ ఇట్ అవుట్. గాడెసెస్ అంటారు. ఇప్పుడు మళ్ళీ పోతరాజు, మళ్ళీ సమ్మక్క, సారక్క, మళ్ళీ ఇటువంటి వాళ్ళని ఏమంటారండి?
వనదేవతలు అంటారు.
వాళ్ళను డీటీస్ అంటారు. వాళ్ళని ఏమంటారు? డీటీస్. పోచమ్మ, సీతమ్మ, ఇది వీళ్ళను డీటీస్ అంటారు. వాళ్ళు అది చెప్పదలుచుకున్నది. అంటే ఇందులో గాడ్లో కూడా రకాలు ఉంటాయని అంటలేను, కాకపోతే ఏంటంటే చెప్తారు. లార్డ్ వెంకటేశ్వర అంటారు, అంటారా లేదా? గాడెసెస్ పార్వతి అంటారు, కాకపోతే గాడెసెస్ పోచమ్మ అన్నారు, పోచమ్మ డిటి అంటారు అన్నట్టు. అది చెప్పడం. ఇప్పుడు హ్యాండ్సమ్ అనేది మొగళ్ళకు వర్తిస్తుంది, బ్యూటిఫుల్ అనేది ఆడవాళ్ళకు వర్తిస్తుంది. అంతేనా అండి? మరి ట్రాన్స్జెండర్ కి ఏం వర్తిస్తుందండి? రెండు
ఏంటంటే
వర్తిస్తాయి.
ఏమో.
రెండు వర్తిస్తాయి బికాస్ ఈ ట్రాన్స్జెండర్ మీన్స్ ఈజ్ హ్యావింగ్ ద ఆల్ ద టూ క్వాలిటీస్. సో ద డిటి అనేది ఈ చోచమ్మ వీళ్ళు పోతరాజును ఇట్లాంటి వాళ్ళని డిటి అంటారు. కాంట్ బి ట్రాన్స్ఫర్డ్. అటువంటిది డెడికేటెడ్ టు ద డిటి. ఇప్పుడు డిటికి తెచ్చి పెట్టినవి అవి ట్రాన్స్ఫర్ చేయలేము. సపోజ్ మీరు ఒక కొబ్బరికాయ ఇచ్చింది అనుకుందాం. ఏది కొబ్బరికాయ ఇచ్చిండ్రు, పలగొట్టిండ్రు, మొత్తానికి ఏది చేసిండ్రు, మేకపోతే ఇచ్చిండ్రు, ఆర్ ఎనీ అదర్ థింగ్ ఆర్ కన్సర్న్ ఇట్ విల్ బి such which is given offer to the DT cannot be transferred. So that is the thing. And under section 23 of the Indian Contract Act, unlawful object and consideration is one which is forbidden by the law. మనం 23 లో చూసాం మనం. సెక్షన్ 6 చెప్పినప్పుడు again we discuss 23. And nature that would be defeat the provision of law is a fraudulent అయినా, involves a multiple implies injury to another person అయినా, his property or the court regards is immoral అయినా, opposed to public policy అయినా. So these are all the things where it cannot be transferred. Like I give the example, ఇద్దరు దొంగలు ఏం చేశారు, అరే ఇప్పుడు మనము ఓ బ్యాంకును దోచుకుందాం, సరే సగం పంచుకుందాం అని అగ్రిమెంట్ పేపర్ రాసుకున్నారు, సంతకం పెట్టారు, ఇద్దరు విట్నెస్ కూడా ఉన్నారు. అది బ్యాంకు దోచుకున్న తర్వాత ఆఫ్టర్ ద సబోటేజింగ్ ద బ్యాంక్ ఆర్ రాబరింగ్ ద బ్యాంక్ ఓవర్ దేర్, దెన్ దే వాంట్ టు ఎగ్జిక్యూట్ ఇన్ ద కోర్ట్ ఆఫ్ లా ద 50-50%. కెన్ దే డూ సో? Unmute and give the answer.
సార్ లీగల్ గా అది చెల్లదు కదా సార్.
They are the immoral cause they are doing, and is a illegal cause also there. At that instance, they cannot execute it, and the transfer is a not proper transfer, or agreement is a not a proper agreement, you can say. So these are the things which will come under it. Then we any doubt, any clarification you need, you can speak me now.
నో సార్.
Okay. Now the time is 3:25 because I started at the 3 o'clock. Of course, 1 past 3. Then I will end by the 3:45. Then I will ask you because from tomorrow onwards there is a classes. Minor College of Law is conducting the classes for you online in the morning hours. So now I will discuss the later part this thing because everything what I am speaking, everything you are speaking is recorded here. So now the transferor must be competent to contract and entitled to transfer property or authorized to dispose of the transfer of property which is not his own. అయితే ట్రాన్స్ఫర్ మస్ట్ బి కంపిటెంట్ టు కాంట్రాక్ట్. ఇది ఇప్పుడు మనకు కావాల్సింది. ఏది? సెక్షన్ 7 లో ఉన్నది ఇది. హూ ఈజ్ ఎ కాంపిటెంట్ టు ట్రాన్స్ఫర్ మీన్స్ దట్ పర్సన్ ఈజ్ ఎ కాంపిటెంట్ టు ట్రాన్స్ఫర్ హూ ఈజ్ ఎ కాంపిటెంట్ టు కాంట్రాక్ట్. సార్ ఇదేంటి సార్, ఆడ ఎవరంటే మొగ గాంధీ ఆడ అంటారు, మరి మొగడు అంటే ఆడ గాంధీ మొగ అంటారు. అదేంటి సార్? అయ్యా ట్రాన్స్ఫర్ చేయాలంటే అది కాంట్రాక్ట్ కు ఏది వర్తిస్తుందో ట్రాన్స్ఫర్ కు అదే వర్తిస్తుంది. ఇజ్ ఇట్ క్లియర్?
ఎస్ సార్.
సో కాంపిటెంట్ టు కాంట్రాక్ట్ అండ్ ఎంటైటిల్డ్ టు ట్రాన్స్ఫర్ ద ప్రాపర్టీ ఆర్ అథరైజ్డ్ టు డిస్పోజ్ ద ట్రాన్స్ఫర్ ప్రాపర్టీ విచ్ ఇస్ నాట్ హిజ్ ఓన్. సో ఏ పర్సన్ కు ట్రాన్స్ఫర్ హిజ్ ఓన్ ప్రాపర్టీ, లేకుంటే అతసొమ్ము అల్లుడి దానం చేసినట్టయితే. So under section 7 of the Transfer of Property Act, a person will be competent to transfer property if he includes she also, if he or she fulfills the necessary criteria under section 11 of the Indian Contract Act. ఈ సెక్షన్ 11 లో ఏమున్నది? who is a competent to contract. So who is a competent to contract can also competent to transfer the property. Who fulfills the criteria of being major, that is one who has attained the 18 of age of sound mind and who is capable of understanding the terms of the contract and its implications and can be formulated a rational judgment, and one who is not disqualified by law. So these people are competent to contract. సార్ ఆడోళ్ళు ట్రాన్స్ఫర్ చేయొచ్చా సార్ ప్రాపర్టీని?
ఎస్ సార్.
చేయొచ్చు. మళ్ళీ కొజ్జోళ్ళు చేయొచ్చా ట్రాన్స్ఫర్ ప్రాపర్టీని?
చేయొచ్చు కదా సార్.
Transgender also, because they are also human beings and they are competent. Are you following me? And they are majors, they are not insane persons, insane persons. So thus the following will be competent to transfer the property or authorized to dispose the transfer of property which is not his own, either wholly or partly or either absolutely or conditionally. So now the question comes over there. A person can only does so when he is the owner of the property. Then he can transfer it. either partly or wholly or conditionally or unconditionally also. Of course, sometimes the condition also put it over there for the transfer of the property. So a minor is a person who has not completed the age of 18 years. Yes. Then he can't be competent transfer, but there is no provision. I repeat, there is no provision in the law disqualifying a minor to be a transferee. Transferee అంటే ఏంటిదండి? Yes. Anyone?
ట్రాన్స్ఫర్ తనకి రావడం, ఇతరుల నుంచి ట్రాన్స్ఫర్ అయిన వ్యక్తి.
A property to whom it is transferred is called transferee. A property who is going to transfer is called transferor. So that is the transferor and transferee. So for our understanding, we repeat Section 7 of the Transfer of Property Act 1882 lays down as to who is the competent to transfer the property if he or she is not eligible or not competent, then a valid transfer of property cannot take place. So if a person wants to transfer the property, he should be competent enough to make the contract. So therefore a person is a competent to the person can validly transfer the property if he is the owner of that property or he possesses the authority sustainable in law to transfer the same. Yes. Even a agent can transfer the property because agent is acting on behalf of the principal. The term authority can be personal under an agency or acquired under the law or under the direction or the permission of the court. In order to be the competent person to transfer the property, one should have attained the age of majority. So what is the age of majority? Anyone?
18, sir.
Yes, yes,
18 years.
yes. Very good, very good. So if a person is under the Guardian and Wards Act, what is the age of the majority? Yes. Yes, give me the answer.
Sir, 21.
21 years.
21, sir.
It is a 21 at the time the majority would be there. When he is appointed the guardian, at the time 21 years should be crossed, then only he will be competent enough to contract. Yes. In the Raja Balwant Singh versus Rao Maharaj Singh, this is the case law, it was held that the transfer of property by a minor is void. So a minor cannot transfer the property because the same minor cannot make a contract also. Is a void and should be of sound mind at the time of the transferring the property. Also, he should not be disqualified to transfer the property under any law or to which he is subject to. So he should be sound mind and he should be not disqualified by the law time being in force. And he is a competent enough. That means he is more than 18 years old. So that was the thing is observed in Raj Balwant Singh versus Rao Maharaj Singh. Then we see the next case law that is in Sadiq Ali Khan versus Jai Kishore. In this case law, the Privy Council observed that a deed executed by a minor was null and void. Suppose if a deed is executed by a minor or any contract is signed by the minor, it is null and void ab initio because a minor cannot have the right to make a contract or write a contract in a manner because he doesn't know what he is doing because he is below the 18 years. So it was held observed that the law of the estoppel cannot be applied to a minor and a minor is not competent to transfer it. Transfer of minor is valid. So sometimes even it is a valid also. Suppose if he agree that, but by disguise from he said I am a major and he purchased the land but he did not pay it. But you cannot bring an action against him, even though he made the fault, because it is you have to ascertain what is your age. Bring your which certificate should be necessary? Date of birth certificate. If the date of birth certificate is not there, suppose if we are educated, which certificate will be shown? Yes, anyone?
10th class certificate, sir.
10th class date of birth certificate is there. There we can show it. That is enough. It is mentioned that under Section 11 of the Indian Contract, that is already told you is the competent to contract, and it is clearly mentioned over there. But according to Section 13 of the Act, he should be alive at the time of the transfer and creation of the prior interest is required if the transfer is made to be an unborn person. So now we will see how it will work for the unborn person. There is certain stipulation equation is there but in the further classes that will be known. But generally, the transfer take place when a person, means transferor, should be alive. Is it or not?
Yes, sir.
It is a must, because if he is not alive, who will transfer it? Sorry, his wife. But the wife is having a GPA. What is GPA? Yes, anyone?
General power of
Yes, yes. It is general power of attorney. So that is GPA, means general power of attorney. If it is unless until it is advised, then they can transfer it. That what the section 13 says. Now the question comes to the fifth condition. The transfer must be made in the mode prescribed by the Act. That all necessary attestation, registration must be complied with. So whenever you are transferring the property, for instance, you are transferring a house to your daughter or your son. At that instance, there are registration papers out there. Or if you don't want to transfer in the form of a sale, okay, you can transfer in the form of a gift, and where its a tariff is different. If the gift tariff is less and the sale tariff is more, because stamp duty you have to pay it, so that will vary depending upon the value of the property. So here what I want to say is section 9 of the act, it is immaterial to sufficiently register a stamp and attest the instrument to avoid the future dispute. So to avoid the future disputes, please maintain the register, maintain the proper stamps, and registration is must. The property must be transferred by a valid instrument that is executed with the transferor in writing and is attested and registered. So a transferor should have to put it either in his own handwriting or by the mechanical device, but his signature should be there with the two witnesses. So a transfer of property can be executed without a written instrument where writing is not expressly necessary under the law. So sometimes now even a oral transfer also can be valid, but to avoid the legal complication, it is more better that it should be put in writing and registered and attested by the two witnesses from both the parties. So that will be the quite good idea. There are some instruments under the Act which require to be in writing, though they may not be registered, like the sale of immovable property of the value rupees 100. Of course, this value is 100 is now it is inflation 100 doesn't make any sense at all. So and above, that is if 100 and above would be there, they say it should be in writing. And the exchange or a gift, etc. Also, there are some which may be in writing and registered with the relevant authority, like the sale of tangible immovable property of the rupees 100 or more than that, it should be registered. Gift of immovable property should be registered in such a way. So that is the fifth condition, essential condition, that the transfer of property is concerned. Then we switch on to the section 6, that the transfer must not offend the rule against the perpetuity. So what is the perpetuity we'll see in the future classes, in coming classes, but at the time being we see the section 14 of the Transfer of Property Act, which highlight the rule of perpetuity. What is meant by perpetuity? Anyone? Yes, if you would know it, give me the answer. If you don't know it, you say pass on.
Guttule, sir.
Yes, then perpetuity means continuity. Perpetuity means continuity. Perennial and also a continuity, because Ganges is a perennial river అంటారు. ఎందుకంటారు?
Sir,
Ganges, గంగా పెరెన్నియల్ రివర్ అంటారు. ఎందుకంటారు?
జీవనది
జీవనది
ఎప్పటికీ
అంటారంటే
ఉంటుంది.
ఎప్పటికీ నడుస్తుంది కాబట్టి దాన్ని గంగా జీవనది అంటారు. So no transfer of property can take place or operate to create an interest which is to take place after the lifetime of one or more persons living at the date of such transfer, and the minority of some persons who should be in existence the expiry of the period and to whom interest created is to be belong to him attains the age of majority. So what is the perpetuity will also have in further classes, but here a house or any property, either movable property or immovable property, ఎన్ని తరాల వరకు మీరు ట్రాన్స్ఫర్ చేయగలుగుతారు? ఎస్,
ఒక్క తరం వరకే సార్.
సో జనరలీ దేసే అట్లీస్ట్ 2 తరాల వరకు వీ కెన్ మేక్ ఇట్ అవుట్. కాకపోతే కండిషన్ ఏంటంటే థర్డ్ తరం వచ్చే వరకు అసలు ట్రాన్స్ఫర్ ఉండడు, అయిపోతుంది. ఎందుకంటే అప్పటికే 100 కన్నా ఎక్కువ అయిపోతుంది. So now the question comes over there. A transfer property to B, okay, good, to his lifetime, very nice. After that of the B, it goes to the C, okay, very good. So after the death of the C, it goes to the his son. కాకపోతే ఇక్కడ ఏంటిదంటే ఒక సన్ పోయినప్పుడు ఎవరైనా ఒకరు బతికుండాల. ఇప్పుడు ఏట్లైనా సత్తడు, అప్పటి వరకు ఉంటాడా? ఏది సికి కొడుకున్నది పుట్టేంత వరకు ఉంటాడా? అంటే తక్కువ ఏజ్లో ట్రాన్స్ఫర్ చేసింది అనుకో ప్రాపబిలిటీ ఉంటుంది. కాకపోతే ఏంటి, ఒక్క లైఫ్ స్పాన్, రెండో లైఫ్ స్పాన్, అంతే. ఇక రెండు తర్వాత ఇక నో క్వశ్చన్. ఎందుకంటే అప్పటి వరకు రెండు లోపట కడుపులన్నా ఉండాలి బిడ్డ. ఎవరు? రెండో ఆయన చచ్చిపోయినప్పుడు. ఆర్ యూ ఫాలోయింగ్ మీ? Of course, don't worry now, because we have a separate chapter, rule of perpetuity. There we can learn in detail the thing with animation. I will show you at the time. But time being, they say it is only for 2 lifetimes maximum. The third lifetime will not come into the picture. So we will study it in the later classes regarding the rule of perpetuity. Ensure that one cannot postpone the vesting of the property in transfer beyond a certain limit. ఇక్కడ సర్టన్ లిమిట్ ఏంటిది? 2 తరాలు, 2 తంతెలు, means 2 generations. Generally you will follow it. Yes, illustration చూడండి ఇక్కడ. A gives a piece of land to his friend B for life. Okay. B బతికినంత వరకు the land belongs to B. Who gave? A gave. ఇవి ఇక్కడ ఎవరు ట్రాన్స్ఫర్ చెప్పండి.
ఏ ట్రాన్స్ఫరర్, బి ట్రాన్స్ఫరీ.
వెరీ గుడ్. సో బి ట్రాన్స్ఫర్ అయిపోయింది ఫర్ లైఫ్ వరకు. ఆ తర్వాత ఆఫ్టర్ దట్ టు హిజ్ డెత్ టు హిజ్ ఫ్రెండ్ సి. అంటే ఎవరు చనిపోవాలి ఇక్కడ?
బి చనిపోతే.
బి చనిపోతే సికి వస్తుంది. సి ఫర్ లైఫ్, సి కూడా మరి లైఫ్ కు. దెన్ టు హిజ్ ఫ్రెండ్ డి ఫర్ లైఫ్, అండ్ దెన్ టు ద సన్ దట్ మే హ్యావ్ బార్న్ టు బి. అంతవరకు ఉంటుందా అండి ఇది? సో దెన్ టు హిజ్ ఫ్రెండ్ డి ఫర్ లైఫ్, అండ్ దెన్ టు ద సన్ దట్ మే బి బార్న్ టు బి. అంటే అప్పటి వరకు బి సన్ ఉన్నాడు అనుకుందాం, లేదనుకుందాం, అసలు అప్పటి వరకు ఐ డోంట్ థింక్ ఇట్ విల్ కంటిన్యూ. సో మే బి బార్న్ టు బి ఫర్ హిజ్ లైఫ్. బి కెనాట్ అలినేట్ ద ప్రాపర్టీ బికాస్ బి హ్యాస్ ఓన్లీ లైఫ్ ఇంట్రెస్ట్. అఫ్ కోర్స్ ఇక్కడ బి మాత్రం అలినేట్ చేయొద్దు, ఎందుకంటే బి చచ్చిపోయిన తర్వాత ప్రాపర్టీ సికి వెళ్తుంది. సో హీ డజంట్ హ్యావ్, ఓన్లీ కండిషన్ ఏంటంటే హీ కెన్ ఎంజాయ్ ద ప్రాపర్టీ బట్ హీ కెనాట్ సెల్ ద ప్రాపర్టీ. So B cannot alienate the property because B has only a life interest. Further, neither C nor D can alienate the property. C would cannot alienate the property, and D also cannot alienate the property. The property legally vests with the only B for his lifetime. So ఇందులో ఏం చేస్తారంటే ఓన్లీ ప్రాపర్టీ లైఫ్ టైం వరకు B ఉంటుంది. ఆ తర్వాత C చచ్చిపోయిన తర్వాత ఆటోమేటికల్లీ the C is having the son, then that property goes to his son. But at the time C should be present. That's the more important. So that is the perpetuity. We will study it in detail, section 14 in the further classes. But time being, this much is enough for you. Still we have the 4 minutes with us. Let me finish this one. Yes, number 7th is if one transfer interest is created in favor of unborn child, subject to the prior interest created by some transfer, it must be exhaust the whole of the remaining interest of the transferor. So ఇక్కడ అన్బార్న్ పర్సన్ కూడా ఏమవుతుందంటే, when the unborn person is conceived over there, at that instance, means at the time of the conceiving, that B should be there. Of course, without B, he will not be conceived. Means the wife will not be conceived. That is the point what I want to say. So conceiving at the time, the father should be alive. That is what the section 7 says. But we have again a separate study there on the section 13 of the Act. Transfer cannot be executed directly in a favor of unborn child. అయితే డైరెక్ట్ గా మాత్రం అన్బార్న్ చైల్డ్ కి ట్రాన్స్ఫర్ కి ఇవ్వలేము. ఎందుకు? ద రీజన్ ఈస్ దెర్ ఇస్ నో బడీ టు టేక్ కేర్ ఆఫ్ ద చైల్డ్. నెంబర్ 1. నెంబర్ 2, ఈవెన్ ద చైల్డ్ కుడ్ నాట్ టేక్ కేర్ ఆఫ్ హిమ్సెల్ఫ్ ఆర్ హర్ సెల్ఫ్ ఎట్ దట్ టైమ్. హౌ కుడ్ హీ ఎక్స్పెక్ట్ దట్ హీ విల్ టేక్ కేర్ ఆఫ్ ది ప్రాపర్టీ? సో దట్ వాస్ ద థింగ్. యాక్చువల్లీ దే సే there are some conditions should be there whether father should be allowed. At that instance, the unborn child, the property can be transferred. Of course, we'll make it a detail in further classes. So unborn person must be in the existence when the prior interest comes into the end. Yes, if the B dies over there, by that time when the B alive and the C should be conceived in her mother womb. So that is the point, the same section 13. And the last point is the 8th is said, if the transfer is conditional transfer అయితే ఏ విధంగా ఉంటుంది? The condition must be illegal or impossible. So if the condition should not be illegal and impossible or immoral or opposed to public policy also, that is under section 25, when the condition imposed becomes impossible or unlawful or immoral or to be complied with, the interest accruing to the transfer of such property dependent on the condition fails. Thus, where the condition is void, the transfer becomes void too. So the condition is a void condition. The reason is because it is illegal, immoral, and opposed to public policy. Then definitely such a condition becomes void too. So these are the things which I want to share with you of the today class. And later on, I will ask you. But let me close down my recording so that it will not be recorded. So this is the thank you very much that I put it on the slide, and I think that you could see that what I put it on the slide. Is it not? Say yes. So with this, I would like to close down my recording first because my every say would be recorded. So I want to close down the stop.